Welcome back. In our last couple of lectures, we talked about one of the most iconic courts in American history, the Warren Court, which sat in the mid-50s and throughout the 1960s. Today, we're going to talk, and in our next lecture, we're going to talk about the role of the judiciary more generally. Because, of course, when a lot of people think about the Constitution, they think about the court, the case law, not just the Warren Court, but courts generally. The Constitution says a little bit about courts, the written Constitution. It talks about the judicial power of the United States. But it doesn't give us a full account of all the different components of that judicial power and what judicial power really is all about. To some extent, it leaves unspecified, unwritten, if you will, all the components of judicial power. So we're going to talk in today's lecture and the next one about the components of judicial power. And in particular, we're going to end with a discussion about how to think about judicial precedent. What happens when the precedent seems to say X, but the written Constitution seems to say Y? Which should trump and why? What does the written Constitution say about precedent? What does precedent say about the written Constitution? That's what we're going to end with. We're going to try to bring these two into some harmony, some alignment in the spirit of these lectures, which is to try to have an account of the unwritten Constitution, and precedent is part of that unwritten Constitution. It exists outside the terse text of the written Constitution. How to bring that body of precedent into that aspect of the unwritten Constitution into some proper alignment with the written Constitution itself. How to have an unwritten Constitution that coheres with, that fits with, that serves rather than subverts the written Constitution. So, and I'm going to tell you at the end about these two interesting characters. Do you recognize either one? They're maybe not household names or icons, but at the end of our next lecture, I'll tell you a little bit about these two. So, one of the most interesting aspects of the Constitution is that it features multiple references to itself. And sentences that refer to themselves that can often be very interesting, sometimes paradoxical. The sentence, this sentence is a lie. That's interesting. Well, if it were a lie, it would be true, but if it were true, it would be a lie. So self-referential sentences are very interesting. The Constitution refers to itself in a whole bunch of ways. The preamble talks about this Constitution being ordained and established. This Constitution is referring to itself. And that's why we've talked about, for example, how to take seriously the act of ordainment itself and what we could deduce from it. Other provisions of the Constitution talk about how all the amendments are parts of the Constitution, and that parts of a larger whole, parts of this Constitution, valid as parts of this Constitution. And we've talked about how that means that we should have to read the Constitution holistically. And in Article 3, the Constitution also refers to itself in connection with the judiciary, and in Article 6, it refers to judges in connection with this Constitution. The Constitution is supreme law, and judges are supposed to enforce that supreme law and take oaths of office to it. And Article 3 says the judicial power of the United States shall extend to all cases arising under this Constitution. So there are some linkages between the judicial power and this Constitution. So let's talk about a couple of those linkages, and in particular, let's focus on this idea of judicial power, which the Constitution itself is basically setting up a judiciary and giving it a certain role, but not fully specifying all the components of that role, to some extent leaving them unwritten. I want to suggest that there are at least 5 different components of judicial power. And today I'll give you the 5 components, and I'll apply those 5 components to some of the case studies, the Warren Court case studies that we briefly discussed in our previous lectures. And then in the next lecture, I'll talk more about one specific component, the component of precedent. So, judicial power. Well, one aspect of judicial power is simply the power to interpret the Constitution, to say what the law means. This is even implicit in the word's jurisdiction. Article 3 talks about the jurisdiction of courts. And what is jurisdiction? Etymologically, it's two words. Juris, law, juris doctors. They're doctors of law, JDs, and diction, a speaking. So jurisdiction is a speaking of the law. In John Marshall's phrase, the power to say what the law is. And that's just a pure interpretive power. Now, a second and distinct idea is not merely the power to interpret the words, but to implement them, to make them real in the world, to go beyond the text of the Constitution and to make it work in court. So we got a case, Smith against Jones, and it's about two parties and they're haggling over a piece of property, but courts are going to need to come up with judicial tests for doctrine, is what we call them, formulas for who has the burden of proving what, and what's the three-pronged test for implementing this a provision of the Constitution, and what evidence would count in favor of certain propositions, and what is the rule that lower courts and lawyers should sort of understand growing out of this area of law. So not just the power to interpret, second component, the power to implement, to make the Constitution work as in-court law, as justiciable law. A third idea of judicial power is the power to decide the case. Smith against Jones. Well, does Smith win or Jones wins? And to issue a binding judgment. And even if other people think the court is wrong, they don't go beyond the judgment. The judgment of the case settles the issue definitively between the parties. If the court rules for Smith, Smith wins, even if you think that Smith got a raw deal. You're a president or some other government actor. It's enough that the court decided it. It is res judicata. Res is R-E-S. It means a thing. Judicata, adjudicated. An adjudicated thing, a done deal. Res judicata is the power to decide definitively the judicial case as between the parties. It, too, is a component of judicial power. The power to interpret, the power to implement, the power to issue a binding judgment, a binding on the parties, the judgment power. One scholar has referred to it as res judicata. Relatedly, courts, in the course of ruling, they give reasons, and those reasons can be appealed to by later courts. Those reasons have a certain precedential weight. This is sometimes called by judges stare decisis. It's about standing by a previous decision, letting an earlier logic stand in subsequent cases. So the question, though, and this is much less absolute than res judicata, the power to lay down a precedent of a certain weight, but the question is how much weight and what kind of weight and what would outweigh a precedent, the logic of a precedent once decided when it comes to a later case, not involving Smith versus Jones, but involving White versus Green. So the power to interpret, the power to implement, the power to decide the case in a judgment, res judicata, to lay down precedent of a certain weight. Finally, the power to remedy a violation of rights. Sometimes often the Constitution will say, you may not do this, but it doesn't say what happens if government does do what it's not supposed to do. John Marshall, building on Blackstone, basically said, ours is a system of a rule of law, and the rule of law means that for every right, there should be a remedy. And Blackstone had said this as well, and for him it was like obvious in the first principle in the same way that it was obvious to him that a person couldn't be a judge in his own case. These are basic, albeit unwritten, principles that frame the entire constitutional project. We encountered earlier Blackstone saying persons can't be judges in their own case. Now we're talking about another Blackstonian precept that John Marshall, in a case called Marbury versus Madison, featured front and center, that for every right there should be a legal remedy in a court, that the power of the judicial power encompasses not merely the power to say what the law is, but to remedy violations of law. So now let's take those 5 components and apply them to a few of the case studies that we just canvassed involving the Warren Court, the power. Remember these components of interpretation and implementation and res judicata and stare decisis and remediation. So let's take Brown versus Board of Education. As a case about the meaning of the Constitution, you might think Brown is just crystal clear. The Constitution says equal. Segregation wasn't really, in fact, equal. Equal means equal. There's no textual exception saying equal means equal except when it comes to segregation or except when it comes to schools or whatever or buses. Equal means equal. This ain't equal. Next case, pure interpretation. Okay, so far, that's good. But here's what Brown said 2 other things. It said that it applied in the field of education. And so it said equality, 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 but it also said education, 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 and apparently didn't. We think that Brown overruled Plessy. It actually didn't say so. It said Plessy was a transportation case. This is a case involving education. We hold that in the field of education, separate but equal has no place. So what's up with that? If equal means equal, why did they somehow say in the field of education? And why did they say separate is inherently unequal? I mean, the word separate doesn't mean unequal, and it's not logically and obviously unequal. The framers of the 14th Amendment didn't think that separation would always, everywhere, be unequal. And in fact, we believe in separate but equal. We believe separate can be equal in certain areas. When it comes, for example, to certain kinds of sex discrimination, we can say, well, the boys have their hardball team and the girls have their softball team. And boys' gymnastics, it's separate and it's got slightly different rules than girls' gymnastics. You know, different uneven parallel bars versus even parallel bars and all the rest. It's separate. Boys' restrooms and locker rooms and girls' restrooms and locker rooms. So separate can be unequal. So what's going on here? If you think that Brown was saying separate was unequal as a matter of interpretation, it's kind of confused. If you think instead Brown is saying as a matter of implementation, look, here's the thing. Separate can be equal. It can be unequal. Who has the burden of proof? Before Brown was decided, in effect, plaintiffs every time had to prove that the separation, the segregation, the formal race classification was unequal. And that put a lot of, because courts have to come up with rules of proof for courts. Who has to prove what, how, what are the sort of the prongs of the doctrine? What things do you have to prove in order to make out your ultimate case of constitutional inequality? What are the little steps that you have to go through in the court? And before Brown, in effect, plaintiffs had to show the inequality. Well, here's the unequal drinking fountains, and here's, the unequal class sizes, and here's the unequal funding. After Brown, the presumption is different. We're going to presume that separate is unequal. Separate, it's not so much that it's inherently unequal, it's that we think it's inevitably unequal. As a matter of history, we've seen now enough Jim Crow cases to know that almost always when we look carefully, we find inequality. So now we're going to change the burden of proof. The burden of proof is not going to be on, in effect, the government to show that there's nothing unequal about this. We're going to presume inequality. That's in the domain of implementation. Because the Constitution can't, in the nature of things, specify all the burdens of proof and all the rest. But if the court had done anything else, it really wouldn't have vindicated the idea of equality, made it real on the ground. It would put all sorts of burdens on discriminating against blacks and their lawyers to prove it case by case. That would have been very expensive. It would have encouraged shamming and winking by state judges who were under pressure by state legislatures to uphold Jim Crow. This was a nice, clean rule, a clean implementation rule. Separate is basically inevitably unequal. Why, though, limit it to education? Because if it's unequal in education, isn't it also unequal in public beaches and in golf courses and in marriage laws that said blacks can only marry blacks and whites? Well, the court didn't say that in Brown. It said in education we hold that separate is unequal and Plessy has no place. So what's going on with that? Remember, precedent plays a role here, and it would have been awkward for the court in the same day that it's invalidating all sorts of Jim Crow laws in the federal government in Washington, D.C., and the states. At the same time, it's throwing out hundreds, if not thousands, of educational segregation policies. It also had to formally overrule Plessy. So it didn't quite. Today, we understand Plessy to have been overruled, but only in retrospect. At the time, the court said education, education, education. And only later said, oh, by the way, that's true in transportation too. And it didn't give a lot of reasons when it said, oh, by the way, just cited Brown, which had said education, but said, oh, yeah, transportation too. Oh, and in 1967 said, oh, yeah, marriage laws also. Marriage laws can't be segregative. The marriage laws in some states had said whites can marry whites and blacks can marry blacks, but blacks can't marry whites. And the deep logic of Brown, that separate is inherently unequal, suggests that that's unconstitutional, but they had limited to education. Why did they do that? Because if they had said in 1954 that they didn't, in the end, invalidate what were called miscegenation laws, which is really segregation in marriage, laws that people could marry those only of their own race. They didn't hold, the Warren Court didn't invalidate that until 1967. And Earl Warren was there. He's an important, he writes that opinion. But in 1954, he doesn't say that. And why not? Because the judicial power is not just merely to say what equality means, but to make it real in the world. And if he announces in 1954 that miscegenation laws are unconstitutional, he's going to make it harder to implement Brown. He's going to create even more of a backlash, because the resistance to Brown versus Board of Education, much of it involved issues of interracial dating and socialization, involved miscegenation. A lot of parents of fair-skinned white girls were really traumatized by the prospect that their white girls would be in the same classrooms and schools as black boys and might socialize with them and maybe become romantically involved with them. And had the Warren Court said, yes, actually, miscegenation laws are unconstitutional too, in 1954, the same day it announced Brown versus Board of Education and Bowling versus Sharp, it would have made the implementation task of Brown and the remedial task of actually making these equality rights real on the ground all the more difficult. And so maybe, and it waited until 1967, and by 1967, the world had caught up to the Warren Court to some extent. Summer of Love. Blacks are now voting thanks to the Voting Rights Act of 1965. Congress has weighed in support of Brown with the Civil Rights Act of 1964. So the president is on board enthusiastically, Lyndon Johnson, and so is the Congress with these iconic statutes. Dr. King has given his speech talking about people holding hands together and singing together the words of the Negro spiritual, free at last, thank God Almighty, we are free at last. That was an integrationist moment. That hadn't happened in 1954. It had happened by 1967. So when the court announces that in Loving versus Virginia, that's the case in 1967, it has a much better prospect of making that stick. And only a few states really were trying to very emphatically prohibit miscegenation by 1967. 1954, a different world. And if you think the judicial task is merely one of interpretation, you'll miss some of those elements of Brown. How it had to deal with the precedent of Plessy, how it had to deal with implementation and remedial issues as well. Well, let's take a couple more examples, and then we'll start talking about precedent in the next lecture. Let's take the example of prayer in the public schools. The court announces these precepts that there have to be religious liberty and equality, and there's massive backlash. States are still trying to sneak organized prayer into the schools, and the court reacts to that by pushing back and maybe overreacting. A later case, after the Warren Court said a state can't have a law in its schools simply allowing a moment of silence. And what's wrong with a moment of silence? The government isn't composing the prayer. People are free to think what they want in that moment. Some people are free to pray. Other people are free to think about baseball. Atheists are free to think, atheist students, heretical thoughts. The court, after the Warren, started to move away from equality as the idea toward this idea of separation of church and state. And that phrase doesn't appear in the Constitution. That doesn't mean it's wrong. All sorts of other phrases don't appear, like the rule of law. But separation, I think, was not, and so separation could be permissible if it's a sensible implementation of the idea of equality. But was it a sensible implementation? Because separation can sometimes actually work to undercut religious equality. Let's take a system, for example, where everyone gets a computer, every kid in public school and in private school that doesn't have religion gets a computer to do work. Now, what happens if a kid wants to use the computer at a religious school? If you think the idea of equality is the key, well, you say, well, everyone gets a computer. It doesn't matter whether you pray or not, whether you're a religious school or not. If the schools teach reading, writing, arithmetic, you get the computer. We don't discriminate in favor of religion. We don't discriminate against it. That's the equality idea. But if you think as the separation idea, you say, oh, no, we can't allow that. We can't have kids in religious schools using computers because then the government wouldn't be completely separate from the religious school. Separation taken to the extreme can actually lead to discrimination against religion, and the core idea is equality for all faiths and the absence of faith. The core idea is not separate, but equal. And so getting in our minds what the key constitutional concept is, and when implementation actually starts to undercut that concept, that religion cases are, I think, a useful reminder. And in recent years, the court has moved away from separation as the metaphor and focused more on equality. I'll give you one final example of how these sort of concepts play out. Let's think about voting. So if the Equal Protection Clause were the basis of voting rights, well, of course, all votes have to count equally because the word says equal. It says equal protection, but the Equal Protection Clause probably isn't the proper basis. That's about persons, not citizens. It wasn't about voting. I think the proper basis is probably the Republican Government Clause and the idea that and the 14th Amendment, Section 2, that says the right to vote shall not be abridged. And maybe it's possible to imagine certain societies that are tolerably Republican that have some unequal weighting of votes. So maybe in the domain purely of interpretation, Republican government doesn't mean that every vote has to be counted exactly the same, that every district has to be exactly the same size. Maybe you could have some inequality of district size and still be a genuinely Republican government. Okay. So in the domain of interpretation, Republican government doesn't automatically equal districts. Unequal districts are not inherently un-Republican as a matter of interpretation. But now think about implementation. Okay, so some inequality is permissible, but how much? Is 10% variation between the districts okay? What about 20%, 30%? At some point, let's go back to that earlier hypothetical. Suppose the legislature says the 51 most senior members of the legislature, their households are themselves districts. So they and their households vote in these 51 districts. The rest of the state, 49 other districts. And that means that these 51 people have a permanent lock on power. Well, that goes too far. Obviously, that's not Republican. That's an aristocracy. That's an oligarchy. That's ridiculous. But if that goes too far, how do you implement, in a judicially enforceable, clean way, the principle? And here's one thing that equality has going for it. It's a nice, clean, bright line rule as a matter of implementation. And when you understand that the judicial power involves not just interpretation, but implementing things in the real world in the way that judges can enforce and lower courts can understand, appellate judges can enforce, lower courts can understand, attorneys can understand, the rest of the government can understand, one person, one vote has a certain implementational cleanness that's really quite striking. Okay, we've talked about some of these aspects of judicial power: interpretation, implementation. I'm actually, in the next lecture, going to talk a little bit about the remedy component, say a little bit more about the exclusionary rule. Maybe that'll illustrate the remedy component. But we're mainly going to focus on the role of precedent, on stare decisis, and try to figure out when we should go with precedent and when we should go with the written constitution, when precedent and the written constitution seem to point in different directions. Stay tuned.